No, in fact, what Harry has done, he has actually given the summary of all the different sessions we are going to have next 2.5 days. That's why I asked him, because I want to confine myself to a very specific issue, whether the Electricity Act 2003 has failed to deliver to the consumer. I want to really confine this session to the consumer. Otherwise, we will be again going all over. Now, if you see the Act of 2003, it has got very specific provisions for consumer protection. Now, that is all covered, and you will find that the most of the state regulators have a standard of performance. The FOR has also come with a model standard of performance. Then also the conditions of supply, what the consumer has rights if you want a supply. Because all these things are really part of the regulation, part of the law. And also the third important thing is that you have a consumer grievance redressal forum and you have a electricity ombudsman. Those are the very specific things which I had done. Now whether they are working in practice or not, those are the different matters. But then these are the things which our Act has given. Now when I am talking of the Act, the main focus of the Act was how to make electricity cheaper, affordable. That was to be done through competition and choice. And that is something which is a much bigger issue. And whether it can do or not, I don't think the Act, and when we talk of the Act, we have to take the Act coupled with judicial pronouncements. Whatever Supreme Court has decided is the law today. We can't go by saying that this was the Act, this is what we had intended. This is something which will be, and there are some issues which still have not been finally decided. They are with the Supreme Court, and till the Supreme Court decides, that's why we will have to either change the law, and that being the case, the issue comes is that has the consumer really benefited? To some extent, I will say that because of this consumer protection regulations, there is some relief for the consumer. Otherwise, consumer was always terrified of the utility that if he gets a bill and if he does not pay it, it will be disconnected. Today, there is a provision, but again, in practice, you find it again very difficult. That's why as a regulator, I have found that people used to call me and say, can you help me? So that means it's not this thing. And again, the very large-scale failure, if you ask me, of the consumer is my experience in MERC, when we found that now here the utilities were no different, whether it was public utility or the private utility or a municipal utility. They all acted similarly, and actually it started with BST, which is the municipal utility, which would send 3-year-old bill to consumer, say, oh no, that bill was wrong, this is the new bill you have to give. And that's the time when the MERC intervened, and we said, put a limit that you can't go beyond this thing. The matter went up to Supreme Court, and what happened, Supreme Court upheld the right of the Regulatory Commission, but there were something like more than 1.5 lakh consumers affected by that. But they said, no, the procedure was wrong. Now you have to again start de novo. So with the result, the consumer did not get that benefit at all. So again, this is a complete failure of the, I'm talking of the legal failure which I have done. And other example also is what the law has provided is interpretation, because we have a BST which runs bus service all over Mumbai and even outside Mumbai. And with the recent Supreme Court judgment, it's very ridiculous. The consumers who are in the BST area, they are only up to Mahim, but they are subsidizing BST transport even in the suburbs, and even the BST has extended services outside Mumbai city. Now, how can that be justified? I mean, this is something, again, that's why I said when we take the law, we had to also consider as it exists with the Supreme Court our final pronouncement, so that becomes the law. So with this introduction, I thought we'll just confine ourselves to this thing. The bigger issue is that competition and choice. And that's why when we talk about open access and all this is only to bring in competition and choice. No other purpose was there. And let us remember, what was the political consensus for 98 Act? It was only two things. National Development Council had agreed that the tariff determination should be done by independent authority, and agriculture tariff should be at least 50% of the average cost of supply. And when it comes to the Electricity Act 2003, it was only the amalgamation of all the laws but I don't think there was any political consensus. So the issue still remains is that when the tariff, so again, we are finding this thing, different thing. So I'll hand you over to now my colleague, Uma Shankar, who has just retired as Secretary Power, and how he looks at the Act.